We are live.
All right, good. So we're back with Senate Health and Welfare. We're moving on to S-28. Looking at a bill that has some language correction from a bill passed last year relating to certain legally protected healthcare services. And we have on remote Sharon Tobor, a policy analyst for the Right to Life. Sharon, welcome. Are you there?
I'm there. Thank you.
Terrific. Okay, so and you've got about 7-10 minutes, so if you could keep it to 7, that would be great. Time for questions, and then we're moving on to David Herlihy for his 7 to 10 minutes as well. Go ahead.
All right. As you said, my name is Sharon Toborg. I'm a policy analyst for the Vermont Right to Life Committee, and I want to thank you for accepting my request to testify here today on S-28. As Senator Lyons mentioned, S-28 amends language contained in Act 15, which became law less than 2 years ago in May of 2023. Act 15 included provisions specifically targeting pregnancy resource centers for regulation because they do not provide or refer for abortion. And despite some testimony that those provisions would be challenged as unconstitutional violations of the center's free speech rights, they remained in the bill as passed. And as anticipated, in July of 2023, the National Institute for Life Advocates and 2 of the pregnancy resource centers located in Vermont filed suit in federal district court challenging the provisions. Oral arguments were heard by Judge William Sessions.
Sharon, I understand you're trying to give us your perspective on what's happening within the courts. Our interest here is how the language improves the bill. And so I understand that there is a court case out there, but the bill itself has nothing.
Senator, I think the changes being proposed in this bill are directly related to that court challenge.
Okay,
and
I
that's
want to
why I'm
clarify.
discussing that now.
As one of the lead sponsors on the bill, I would like you to know that the motivation for this is that when the bill passed the Senate, we had different language. The House changed it. We feel compelled to change it back to the Senate language, period. That is our intent to clarify the language, to make it across the board for everyone. So that's my comment. So try to finish up your testimony.
All right, I'm not sure I concur with that being everyone's intent as far as this bill goes. However, I will say that S-28 contains its own set of constitutionally problematic provisions. It defines all advertising about healthcare services or proposed service in Vermont as commercial speech, even if there's no economic motive underlying the speech. And the courts have ruled that in order to be considered commercial speech, which receives less First Amendment protection, certain tests have to be met. It's not permissible to simply decree speech as commercial as an excuse to restrict it. But that is what Section 2493 does. The speech of any person, not just healthcare providers advertising specific products or services, or persons with economic motivation, or persons speaking about specific healthcare services, but any healthcare service, would be regulated by this provision. And we believe that this would chill the speech of pro-life advocates and others whose opinions on healthcare matters are politically unfavorable at the moment. And we would encourage 2493 to be repealed as opposed to amended. Okay. I do want to be clear that Vermont Right to Life does not disseminate advertising that is untrue or misleading. And the other pro-life groups with which we partner are committed to truth and accuracy as well. However, we are all acutely aware that the current Attorney General, who would have the power to enforce this law and levy $10,000 fines on our organization, is a staunch abortion advocate And the abortion lobby label
So,
many claims about
I-
abortion they don't like to hear as untrue or misleading. One of those,
Yeah, no, thank you. We hear you and, I understand that you.
there's some additional comments I would make, but if you'd like me to be shorter and to the point, if this law goes into effect as written, you will continue to be in court over the language of the provision because it's a violation of the First Amendment rights of Vermonters to speak about healthcare issues. Second, again, regarding the language to be added to various unprofessional conduct statutes. Here again, the language that is being suggested is a violation of the First Amendment. It can interfere with the provision of healthcare services, as the Vermont Medical Society acknowledged. And they noted that in their testimony, the draft language could bring healthcare services to a halt in many settings. And we're concerned that providers at the pregnancy resource centers, again, would not be able to provide the services they wish to provide because of this language. I would also note the S28 furthers the trend of lowering standards for providers of legally protected healthcare, which was begun again in Act 15, where providers who provide telehealth services to patients in other states are allowed to practice even if they are not licensed in those other states, if they're providing so-called legally protected healthcare, which no other providers would be able to do. It would be unprofessional conduct for them to do so. And here in S28, we take that another step further by allowing providers to prescribe abortion pill services based on the results of a questionnaire as opposed to any sort of face-to-face interaction with a patient. Again, that would continue to be considered inadequate and unprofessional conduct for any other healthcare provider. But here we're creating out another carve out for certain providers of these so-called legally protected medical services.
Sharon, you're giving some very good testimony and I appreciate it. And there will be some language changes related to some of the things you're talking about. And I'm going to give you the last 50 seconds, and then we need to turn to David Herlihy for his 10 minutes. Thank you.
All right. Thank you, Senator. We're also very concerned that it would be a very dangerous practice to provide abortion pills only with a questionnaire. I will be submitting my written testimony shortly. There are some statistics about the complications and the risks of providing the abortion pill without a more thorough consideration of who is receiving it. And again, we would encourage you to strike that section from the bill that allows the provision of abortion pills without a face-to-face interaction.
We got it. And if you send us your written testimony, we'll have it even more. Thank you.
I'll do that.
Thank
you, Senator.
And the reason I'm rushing along is that Senator Gulick has reminded me we have another person on for testimony. So we're going to have David Herlihy come up, and then we have Allison Despathy as well. So David, you're next in line, and then Allison. This is what happens before we get close to crossover. We missed a whole day on Tuesday, so we're making up time. There we go.
I'm David Herlihy. I'm the Executive Director of the Board of Medical Practice. And I'm going to spend some of my precious time just telling you about the board real quickly because we have some members who haven't testified.
So you have Senator Hart, Senator Douglas,
Yeah.
Senator Cummings, Senator Gulick, and Senator Lyons.
So the board is made up of 17 members appointed by the governor to 5-year terms. And we have 11 healthcare professionals, 9 MDs, a podiatrist, and a PA, and 6 public members. These people are charged by the law with overseeing the practice of medicine in Vermont and setting policy for practice of medicine. And I must say the members work incredibly hard. They get $50 a day per diem for each day they meet, which is 2 days a month, and they spend dozens and dozens of hours every month. Our members are really, really involved in our investigation process and in everything we do, I can't say enough about it. We have over 6,000 licensees now. We're up over 5,000 MDs, about 500 MDs in training, training licensees, and 500 PAs.
I think we gotta, yeah, I think move right along, because I think we'll have you back another day.
I'll be very brief on most of the bill. I'm not going to speak about today. Just quickly, we welcome the changes that broaden the reach of the consumer protections. I've worked with you before
Yeah.
on some different bills that were targeting very specific healthcare communications, and we like that. We think that truth and accuracy when you're talking to people about their healthcare is important. We don't have an opinion about the fetal death reporting. I think that the health department is speaking separately on that, and the board doesn't really have an opinion on that. There is one issue though that we really want to spend our time on, and that is in section 3 of the bill. There's one part from section 3 that would create an exception to existing Vermont law that says it is not okay if you're practicing by telemedicine to issue a prescription based on only an online question. And this would change that and do away with that requirement. The board passed, again, I'm going to spend some of my precious time. The board passed a motion that's in my written testimony, but I just want to read it very quickly here because it says it all. Section 3 creates a carve out to the statutory standard for prescribing via telemedicine. The current law, consistent with the board's longstanding position, is that it is unacceptable for a prescriber to rely on only a questionnaire when prescribing by telemedicine. The bill proposes to amend the law by adding an exception that would apply to only prescriptions of drugs to terminate a pregnancy. The board opposes that provision because board members believe that prescribing by questionnaire alone with no interaction between the patient and the prescriber does not constitute quality care. The board's position is that there must be some form of iterative communication, some back and forth between the prescriber and the patient is reflected in the board's policy on telemedicine. Allowing a patient to obtain a prescription by only answering an online questionnaire with no exchange with the prescriber deters communication. Ironically, the findings in the bill themselves include the following language describing the aspiration to, and now I quote, cultivate an environment where best practices and shared decision-making can flourish. The board agrees with that aspiration and believes that two-way communication supports better care. Communication with the prescriber, even if only by a text exchange, allows the prescriber a better basis on which to prescribe. Allowing a prescription to be issued based on just a questionnaire deters communication and thus avoids shared decision-making. Now, it's 30 years ago this year is the first time I testified here in the Vermont State House. This is the first time I've ever seen a bill that had such an obvious conflict between the legislative findings made in the bill and something this bill proposes to do. And I guess the question is, do any of you feel that a special exception to the law that prohibits the issuance of prescription based on only a questionnaire promotes shared decision-making or, as a result, quality care? You heard from another witness that the FSMV model policy on telehealth allows use of an adaptive questionnaire. It does. Though, it was changed in, I think it was 2022. It was a very controversial change and it's very limited. The language says a physician practicing telemedicine utilizing adaptive questionnaires must have the ability to ask follow-up questions, especially when doing so is required to collect adequate information to appropriately diagnose or treat. The board considered that change in the language of the policy when they updated the policy in 2023. They rejected that. They said it's not right for Vermont. They expect a little bit more. And
So do we have your testimony's not coming up when I click on it, so we'll make sure we have that testimony.
yeah,
Because I
can
want to
get
give
that.
Allison a chance, but we
Okay.
hear you and the board is very thoughtful in what it does. I understand.
But if I can have just 30
Yep,
seconds
yep,
more.
Yes,
I
please.
just want to say that I'm limited in sharing facts about cases. So what comes out in public charges or in public decisions, written decisions of the board or in public hearing. So I'm not at liberty to share specific facts, but I can say this. The board's position is very, very much, the board investigates a couple hundred cases a year. It's very much based on what they see reflected in the care that they review in investigating those cases. They feel strongly that communication between the prescriber and the patient is important to quality care. And I know that Senator Cummings agrees with me because I heard you. It's common sense. You don't need to see a couple hundred investigations. a
Okay,
year.
we need,
And this
we need
can
to
go
wrap.
over the telephone,
Okay.
Yes, we
not
can't,
necessarily in person.
we have another witness.
It doesn't,
So we have another witness. We hear you're getting started. You got in conversation right now. We've got to move along and we will have you back should that be necessary. And I appreciate it. And I know you've sent written testimony. We need that very much. And I know you sent me an email about that.
10 seconds more though. Asynchronous is fine. Text message is fine. Telephone is fine.
Okay,
An email exchange in your patient portal is fine.
yeah, I know, and you said this, and so that's key in your
All right.
testimony.
It's
Thank
very
you.
important.
You always bring us good ideas. I appreciate it. Thank you. Yeah, here you go, Alice.
Okay,
Thank
I
you for
will
being
be
here.
quick.
Yeah, we'll
We'll
go over a little bit. We're gonna
Okay.
go over a little bit. It'll take about 5 minutes.
Okay, perfect. Okay. Allison Descappi for the record. Thank you so much for having me. I appreciate all the work you guys are doing and thank you for the time. I really, again, I support this with regards to the consumer protections and you looking for quality care and standard of care and practice. Where my concerns land, I not only, Kiki had me listed as a parent, but I am also a clinical nutritionist. I teach nutrition and health at the Vermont State Colleges for 25 years. I work with thousands of students and thousands of clients. What I see in my practice is literally generations of people, great grandparents to great grandkids. And they come to me because they are looking for, what can I do nutritionally? What can I do on a natural approach? I've talked to these doctors. These are my options. People need options. We need second opinions. We need diversity of thought, and practice develops because of the experience that practitioners and doctors are having. If they've had an issue or they've seen, I have a problem with this prescription, a high percentage of my patients seem to have a reaction, maybe they're not going to use that much. So there's a lot influencing care and practice. And we just want to make sure that doctors are supported in how that evolves for them and their experiences and their research. And also that patients have the options. All of my children were born at home. I couldn't imagine of having my kids at the hospital. It was not comfortable for me, but I was so thankful the hospital was there in case it went wrong, right? And then some people couldn't imagine having their kids at home. They have to be at the hospital. So we need all these options because we're all so different. When I see cardiologists, just really quickly, I'm sorry. I see a lot of I work with a lot of cardiologists and a lot of endocrinologists because of nutrition, diabetes and heart disease. Some doctors obviously will say metformin or do diet and lifestyle. Some doctors will say statins, don't touch statins, maybe red rice yeast extract. So naturopaths, physician assistants, nurse practitioners, they all have their own different personal approaches. I've talked to about 5 lawyers at this point, and the concern that I really hold most is in 2493 on page 6 of the bill. So one, it goes to talking about a person to disseminate or cause to be disseminated to the public. So it's taking it from the pregnancy center and giving it to a person. And so how does that put at risk any of these licensed care providers or organizations or people working for an organization who have different opinions, all based on research? Because as we know, the science is always so different. It differs. Translational medicine is the last thing I want to talk about. It can take 30 years. There's a doctor here. I printed this for you guys. He's out of Stanford. He's an expert in translational medicine. The research can take 30 years to translate from science and research to practice. So who is wrong and who is right? If someone catches the research sooner versus later, when they stopped using Vioxx, when people were promoting margarine over butter and trans fats, who's wrong and who's right? So we just get into these, when does science come into play and how are we limiting people and practitioners in their ability to practice in a way that has been evolved based on their research and their experience individually? The only other place I want to mention, my last thing that my concern is 1354, page 9 on professional conduct. I'm just looking at to confuse or mislead. Who determines what's confusing or misleading? Who determines what is truth? Because you can have conflicting science all within the research. And if one practitioner uses this science, this practitioner uses this science, who's confusing, who's misleading, and who has the truth? And so then we're putting it to the Attorney General to decide that, when science, as we know, is evolving all the time. And so I just want to make sure that we allow this level of diverse practice, all with high levels of quality care, to continue in the state, and that people have access to it. Last statement, we're never going to have people say the same thing all the same time. And we're always going to have, science is dispute. It is debate. It's at the heart of it. And so, and it's constantly evolving. So I just want to make sure that we're not limiting that, because we're going to push practitioners away if they're concerned for having a different thought or a different opinion, and they want to share that with people. So that was essentially my sort of primary.
Good, thank you.
Yeah.
And if you can put it down in a couple paragraphs and get it into Kiki, that would be helpful.
Okay, we just don't want to limit the freedom of speech.
That's good. Thank you. All right, good. So we're gonna call it a wrap today. We're a little late, but thank you all for your patience and your understanding. We're at the end of a long week of catch up.